The Equal Remuneration Act 1976. My dear friends, my name is Umesh Rao. Today's subject is Equal Remuneration Act 1976. This is covered under Labor Law 2. Table of contents. In this class, we are discussing objects of the Act, application of the Act, and what are the important provisions of the Act, penalties for the violation of Acts, and case law. The Equal Remuneration Act 1976. This Act came into effect with effect from 26 September 1975. The purpose of the Act is to make equal remuneration to men and women workers for the same work or work of similar nature. The Act prevents discrimination on the ground of sex. The Act was introduced based on the wishes of the Constitution. What Constitution says? Article 14 of the Constitution lays down the provisions of equality. Article 39 of the Constitution makes a policy securing men and women treated equally, and they have the right to adequate means of livelihood. There is equal pay for equal work for both men and women. Object of the Act. What is the object of the Act? It ensures that there will be no discrimination against recruitment of women. Men and women should be treated at par. It provides the setting up of advisory committee to promote the employment opportunities for women. It says equality of pay for equal work and no discrimination on the ground of sex. Application of the Act. The Equal Remuneration Act 1976 is applicable to major establishments. The central government has issued several orders to bring the establishments and employments under the purview of the Act. For example, the establishments like central government and state government officers, corporations, local authorities, plantations, hospitals, banks, insurance companies, educational institutions, mines, manufacturers of textiles and jute, retail traders such as medical shops, bookshops, stationaries, constructional companies, petrol filling stations, restaurants, hotels, and marts and footwear shops. All these are covered under the scheme. Now, important provisions of the Act. The Act says equal remuneration shall be given to men and women, and there should not be any discrimination. What is remuneration? Act says equal remuneration should be given to men and women. Then what is the meaning of remuneration? Remuneration means basic wages or salary and additional emoluments which are payable either in cash or in kind to a person when he is in employment. It is as per in terms of contract, employment contract, which may be express or implied. So now same work or work of similar nature. What is the meaning of similar nature? Means work in respect of which skill, effort, and responsibility required are same when performed under similar working conditions. Whether the work is in the same or similar nature, how to judge? Broad approach should be taken. It should be practically possible to judge. Factors like skill, responsibility, effort, and conditions of work should be taken into account. The Act has an overriding effect compared to other laws. The Act shall have effect notwithstanding anything inconsistent therewith contained in any other law. The Article 14 forbids the hostile discrimination but not reasonable classification. This applies where equals are treated differently without any reasonable basis. Where equals or unequals are treated differently, Article 14 would have no application. No discrimination to be made while recruiting the men and workers. Men and women workers. The Act imposes the condition upon the central government to constitute an advisory committee. The committee shall consist of not less than 10 members nominated by the government. Half of the members shall be women. The committee will take into account number of women employed, the nature of work, hours of work, and providing employment opportunities for women. Now, penalties for the employer who violate the provisions of the Act. Penalties for the employer who violate the provisions of the Equal Remuneration Act of 1976. The employer is required under the Act to do certain things. It imposes penalty for not maintaining register for men and women or all workers. It imposes penalty for failure to produce the register. It imposes penalty for refusal to give evidence. It imposes penalty for refusal to give information to the department. It imposes penalty who makes any recruitment in contravention of provisions. It imposes penalty who makes any payment at unequal rates to men and women. It imposes penalty an employer who fails to comply with the direction of the government. So this offence is treated as cognizable offence. Fine of rupees 10,000 and imprisonment of rupees 1 year is imposable. Now we will go to case laws. It is the case of IAF officer CB Muttama versus Union of India. Women IAF officer was denied promotion due to gender discrimination. The Supreme Court condemned the defendant and ordered to make good the mistake. In another case, A.N. Rajamma versus State of Kerala, the woman denied the post of peons because she did not know cycling, but the same condition was relaxed to the male candidates. The Supreme Court gave judgment in favor of the woman. In another case, Air India versus Nargish Mirza, the air hostess were shown gender discrimination in their appointment, wages, allowances, and retirement. The Supreme Court gave the judgment in favor of the air hostesses. McKinnon versus McKerjee Company versus Andrew Picosta. Here, woman was a lady stenographer. The employer was paying higher remuneration to male stenographers. The Supreme Court held that it was a clear gender discrimination. The end.